Sean Combs is currently locked up in a federal detention center awaiting his criminal trial, but he has taken every opportunity to bail out. We're going to do a brief history of all of his lawyers' attempts to get their client pretrial release and what the plan will be moving forward. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. One of the key issues surrounding the Sean Diddy Combs criminal case is bail. The fact that since his arrest back on September 16, 2024, and his indictment on sex trafficking, racketeering, conspiracy, and transportation to engage in prostitution charges, he has been locked up behind bars. He's locked up at the Metropolitan Detention Center out in Brooklyn. Now, he has been denied bail, pretrial release, multiple times. So what we're going to do is we're going to dissect these legal efforts that his attorneys have been engaging and have been making to get him out of there, and what the future may hold. So, as we've already explained on sidebars in the past, the MDC, the Metropolitan Detention Center, that is not a place you want to be. It is violent, it is dirty. I mean, it was just the subject of an interagency sweep by federal authorities who confiscated all of this different contraband. And it seems to me that Combs wants to get out of there. And why, by the way, I think it seems his attorneys have been pushing for a trial as soon as possible. I mean, it's currently scheduled for May 2025, less than a year after his arrest. And these kinds of cases, particularly racketeering and sex trafficking cases, which can be quite complicated, they take time. For a trial to happen this quickly, seems to me that his attorneys want this to be put behind him. We want to go on trial as soon as possible, partially to get him out of there. He doesn't want to be in the MDC for another 2 to 3 years as he waits for trial. That's just my theory. And look, my theory also is that I will say, if he is granted bail, and we'll talk about that, his attorneys may try to push that trial date back. Because actually, as we get into this, I think there's an argument that he thought he was going to make bail, knowing he was about to be arrested, and figured, you know what, I'll just be on house arrest for a year, 2 years, 3 years as I await trial. It seems to me they didn't expect that his bail was going to be denied and he was going to be locked up in the MDC, but we'll get to that. Hey, by the way, any business owners out there watching us here on Sidebar, maybe those of you thinking of starting a business? Well, you might want to listen up because we partnered with this awesome sponsor. It's called Odoo, and Odoo is a free all-in-one business management software that provides you with a range of applications that helps with the day-to-day of owning a business. I'll give you an example. I'm the host and executive producer of a YouTube show called Prime Crime. It's on Law&Crime's YouTube page. I want you to watch this. With Odoo's website builder application, I can easily and for free build a Prime Crime website using tools like their AI copywriting and their drag and drop feature. Look how easy that was. 5 minutes later, I now have primecrime.com. So thank you to Odoo for sponsoring Sidebar, and thank you for getting me a Prime Crime website. Appreciate it. And you can build your own website now too. The domain is free for the first year. Just use our link odoo.com/LC-Sidebar2. So the first thing that happened after Combs was arrested in New York pursuant to federal sex crimes charges is that he was brought before Magistrate Judge Robin Tarnowski. And his attorneys submitted a letter to the court on September 17th where they lay out some of their reasoning for why he should be granted bail, pretrial release. And what they say is, look, Judge, Combs has taken a series of actions in anticipation of his arrest and indictment that prove he is, quote, eminently trustworthy, and that, quote, he should be released while he waits for trial. They write, the first thing the court should know is that when it became apparent to his counsel that Mr. Combs would at some point soon be formally charged, he did something extraordinary. He left his home in Miami and traveled to New York, the very location of the prosecutors and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York, offered to tell them specifically where he was, and offered to turn himself in at the appropriate time. Now, as we know, government agents, they arrested him. Nonetheless, they didn't allow him to surrender. But the point is that he voluntarily showed up, showing he is not a flight risk. He is cooperative. He should be granted bail. But Combs' attorneys also explained that Combs, he knew the Southern District of New York was investigating him for months. And his lawyers say, look, we tried to reach out to the prosecutors since March to talk about the case, to talk about the investigation, but the prosecutors, they didn't respond. But after the infamous raids on Sean Combs' properties in March, Combs, they say, actually surrendered his passport to his lawyers. This was back in April. And from there, his lawyers say, you know what else, Judge? We kept telling prosecutors where Combs was going. We kept him up to date on his travel plans, what he was doing. So he surrenders his passport. We are letting the prosecutors know where he's going. Again, he's not a flight risk. Also, they say Combs never left the country, even though he has a private plane. And on top of that, Combs was making efforts to sell that plane, all trying to show that he was acting in good faith, that he's not a flight risk, that he can be trusted. And from there, what Combs' counsel did is they proposed a bail package. And what it was a $50 million bond, $50 million, co-signed by Sean Combs and other members of his family, that this would be secured by the equity in his Miami property and his mother's Florida home too. He would restrict his travel to New York, Florida, and New Jersey. His passport would remain surrendered, but also, by the way, his family members, like his mom, daughters, their passports would also be surrendered. This would be in addition to home confinement with GPS monitoring. And they argue that this would satisfy any concern the government would have that Combs is a risk of flight or a danger to the community. And from a legal point of view, from a legal standard, his team said, yes, by law, sure, there is a presumption of detention in sex trafficking cases, very, very serious cases. But they indicate, and this is true, that presumption is rebuttable. It can be overcome. And his attorneys highlight how he is not running from this. They highlight his philanthropic work. They highlight the fact that he's helped in disaster efforts, how he has helped the community, how he has helped people in the music industry, the black community, and so on. Now, not surprisingly, the prosecution opposed this. In their letter to the court, they doubled down on the allegations against Combs that he is violent, that he abuses and sex traffics women, that he possesses weapons. So they're really honing in on the allegations in the indictment. And they wrote, there is no condition or combination of conditions that will reasonably assure the appearance of the defendant as required and the safety of others and the community, not to mention the integrity of the proceedings. As reflected by the gravity of the charges in the indictment, the defendant is dangerous and poses an ongoing threat to the safety of the community. If released, he remains a serious risk of flight despite the conditions offered by his counsel. And I mean, look, they're charging him with operating a criminal enterprise and engaging in the sex trafficking of individuals and forced labor and kidnapping and bribery and obstruction. So I'm not surprised that they're saying this, but talking about that, they also write, most glaringly, the defendant also poses a significant risk of obstruction of justice. Indeed, and as set forth below, during the course of the charged conduct, the defendant has attempted to bribe security staff and threatened and interfered with witnesses to his criminal conduct. He has already tried to obstruct the government's investigation of this case, repeatedly contacting victims and witnesses and feeding them false narratives of events. There are simply no conditions that would ensure that the defendant's efforts to obstruct and tamper with witnesses will stop. That was a big shocker, that last part about allegedly reaching out to witnesses and victims. That was big. That became a big topic of discussion when both sides argued their case in person in front of Judge Tarnofsky. And Judge Tarnofsky in the end told Combs, your behavior warrants detention. Quote, your prior substance abuse and the fact that the alleged violence seems to occur hand in hand with times when you are not necessarily in control of your actions because of that substance abuse. Your lawyer asked me to trust you and to trust him, and I don't know that I think you can trust yourself. And I don't believe that counsel has the ability to control you. So Judge Tarnofsky, due to all of these factors, denied Combs bail. Well, from there, the bail issue moved in front of a different judge, United States District Court Judge Andrew Carter. Now, in Sean Combs' attorney's letter to Judge Carter advocating for pretrial release, they included many of the same arguments that I just mentioned, the same background, but they also updated the bail package. So it includes everything that I had mentioned before, but now they added that when Combs is on home confinement, there are going to be restrictions on visitors. So it'll just be family, property caretakers, and friends who are not alleged co-conspirators in the case. In terms of female visitors, since the main allegation is that Sean Combs had sexually abused and exploited and threatened women, these female visitors would only be family members or mothers of the children. Also, Combs proposed hiring a security company that would monitor him, and also it would provide visitor logs to the court. Combs also promised not to contact any grand jury witnesses, and he would agree to weekly drug testing. And at one point, they also said that his internet and cell phone usage would be taken away too. And Combs' attorneys also addressed some of the arguments that were put forward by the prosecution. For instance, they addressed the infamous 2016 videotape that was released by CNN back in May of Sean Combs beating his ex-girlfriend Cassandra Ventura in a hotel hallway. We believe Cassandra Ventura is the key witness in this criminal case. But they say that that 2016 Cassandra Ventura incident is being mischaracterized by the prosecution, because whereas the prosecution said that Combs had beat up Ventura and then allegedly tried to bribe a security officer to keep it quiet, and this therefore shows Combs engages in obstruction of justice and why he should not be allowed to be released on the outside, Combs' team says, look, this is from 8 years ago. It's not obstruction because under the law, obstruction requires someone acting corruptly with respect to an official proceeding like a trial, and nothing like that was happening at the time. And with respect to Combs allegedly reaching out to victims and witnesses, Combs' lawyer said Mr. Combs is entitled to gather witnesses to defend himself against the government's allegations of sex trafficking and racketeering. As part of that defense, he, with counsel's blessing, has called potential defense witnesses to let them know that counsel would reach out to speak with them. Tellingly, the government does not point to, nor can they, any conversation Mr. Combs has had with a potential witness since he had knowledge of the criminal investigation where he pressured any witness to change their story. The prosecution responded to all that, and I do want to highlight something they said in particular that was really disturbing. They wrote, since at least in or about January 2024, when the defendant was unquestionably aware of the criminal investigation, the evidence shows that he is engaged in multiple freak-offs, some involving the interstate transportation of individuals to participate, has continued to use narcotics, and has contacted multiple witnesses. Some of this conduct has even taken place since the defendant arrived in New York City, allegedly to sit it out and wait to be arrested. The defendant's conduct is demonstrably not cooperative and indeed highlights his inability to abide by the law or counsel's directives. So that was big. In other words, this alleged illegal conduct, including these freak-offs, these coerced sexual sessions that were sometimes drug-fueled, all of this was happening even this year, and his illicit conduct, they say, was happening even when he came to New York right before he was arrested. And when they argued in front of Judge Carter, something very interesting happened. And there was one specific interaction I want to highlight from that hearing. So prosecutors, they really focused on that 2016 tape of Sean Combs beating Cassandra Ventura. And prosecutors said that this shows Combs is violent and that he's dangerous, and that Ventura, what she was actually doing, she was trying to escape a freak-off in that video, that main theme in the indictment, that Combs used violence and threats and drugs to force people into prolonged sex sessions with male sex workers. Well, interestingly, Combs' team characterized that episode not as an instance of sex trafficking or a freak-off, but rather it was a domestic spat. Combs' attorney, Mark Agnifilo, told the court the sex and the violence were totally separate and motivated by totally different things. And then when it came to freak-offs and sex workers, look, that was the way these two adults chose to be intimate. The prosecution countered that and said Agnifilo is minimizing and understating Combs' violent tendencies and what this video shows. And Judge Carter, he agreed, asking Agnifilo about that 2016 tape, what's love got to do with that? Judge Carter was not convinced by the defense's amended bail package or their arguments. He indicated there was still a risk that Combs could obstruct justice and intimidate witnesses, even through associates or coded messages. So he denied bail, he denied pretrial release. What happens next? Well, as Combs appealed this decision to the Second Circuit Court of Appeals, a higher court, he simultaneously asked Circuit Court Judge William J. Nardini to immediately release him from detention while he waits for the Second Circuit to rule, but Nardini denied that. So now the arguments have to be made in front of the Second Circuit Court of Appeals. And in Sean Combs' legal brief to the Second Circuit arguing that he should be released, his attorney's right. This case does involve extreme and unusual circumstances, but none that typically foreclose bail or warrant forcing Sean Combs to defend himself from a prison cell. What is extreme and unusual about this case is that Mr. Combs was detained immediately after he was charged. The sensationalism surrounding his arrest has distorted the bail analysis. Mr. Combs was not released pending trial, even though he offered to comply with restrictive conditions that would have prevented any conceivable risk of flight or danger. And in this motion, Combs denies the government's accusations of obstruction. His attorneys concede that he spoke with people about the civil lawsuits that he's facing, but say, look, he wasn't aware that the Southern District of New York was investigating him when he reached out. And once he realized he was being investigated, they argue that Combs made sure to not continue contact with these people. The motion reads, although the government vaguely described contacts with 2 grand jury witnesses, it proffered no evidence of any threats or intimidation. The government could only state that there were 14 total contacts between Mr. Combs and one witness, and another witness who was contacted, quote, multiple times. Defense counsel explained these contacts involved no obstruction or witness tampering. For example, one witness contacted Mr. Combs not the other way around. She reached out to Mr. Combs and told him, I'm a grand jury witness. After Mr. Combs informed defense counsel, he was instructed not to contact the witness anymore and didn't. And Combs' lawyers argued that the prosecution, they didn't meet their burden to hold Combs until trial. And then in a follow-up brief later on that month, they doubled down on this. They wrote in that filing, Mr. Combs is entitled to release, which has been granted to many similarly situated defendants, including just yesterday, a CEO accused of sex trafficking dozens of young men, including through witness intimidation. The government's request for detention is not based on any genuine risk of danger or obstruction. It is based on a desire to punish Mr. Combs. So that was in reference to how federal prosecutors in New York had charged the former head of Abercrombie & Fitch, Mike Jeffries, with sex trafficking, and he was granted bail. So an interesting comparison there. And Sean Combs' attorneys, they make more arguments that they say the government failed to prove by clear and convincing evidence, which is kind of a middle ground standard, that Combs has to be detained before trial. First, they say, yeah, that 2016 video, it's bad. And in fact, they say Combs' conduct on that tape is indefensible. But they also say he apologized. Remember, he released an Instagram video apologizing 2 days after that was published by CNN. But they also say, look, this was about a toxic romantic relationship. It's 8.5 years old. It's in the past. This is not evidence that he would do something like this in the future. And they also say the bail package that they're proposing, it limits who can be in contact with him anyway. When it comes to the allegation that Combs was reaching out to witnesses, the contact itself is not problematic, they say. What exactly were these conversations? What about these conversations shows obstruction? They say the government has the actual communications. They could describe them for the court, but they don't. In other words, there's nothing there to prove that he was engaging in obstruction or witness tampering. And Combs' lawyers also argue that if you look at past cases, you need to have substantial evidence of obstruction in order to justify pretrial detention. And they say that the case that the government cites, saying you only need to show one episode of witness tampering to justify detention, Combs' lawyers say, no, that's not right. That case that the government cites was about a decision to revoke bail once it was granted, not ordering detention at the start of the case. The defense says the bar to have bail revoked is much lower. You don't need as much evidence to justify that. It's not clear and convincing as you need to have to prove that Combs should be denied pretrial release at the very beginning of a case. It's a very interesting argument. Putting that to the side, the case that the government's relying on in that story, the government had 3 days of hearings, 12 witnesses, all proving the defendant in that case engaged in witness tampering. Here, with Sean Combs, the government's basically saying, look, court, just take our word for it. Look at the allegations in the indictment. Look at what we're alleging. That's enough to show that he's engaging in obstruction. Combs' lawyers say the government has no actual evidence. They didn't present anything that he's been doing anything wrong. Just presenting the allegations in the indictment, Sean Combs' lawyers say, that's a problem. You can't just rely on that. An indictment is not proof of clear and convincing evidence. We don't know if the grand jury that returned that indictment did so because of allegations of obstruction. Maybe they said there's probable cause of racketeering or sex trafficking because of the freak-off allegations, or the kidnapping allegation, or the forced labor allegation. And although obstruction is an underlying crime of racketeering, we don't know if the jury even looked at that. We don't know if that even swayed the jury. So prosecutors, you can't rely on that indictment to say that Sean Combs should be locked up. And Sean Combs' lawyers from there, they move on to another argument put forward by the government, because the government had said, look, it's not fair to have a two-tiered justice system where Sean Combs can stay free on sex trafficking and racketeering charges because he has the money, the financial resources to turn his home essentially into a private prison, whereas you have a defendant of lesser means who couldn't put forward that kind of bail package, and they would be denied bail, and they're locked up while waiting trial. Sean Combs' attorneys responded to that and said, "We are offering this package, these conditions, because Sean Combs is wealthy. The government said he's a flight risk and a danger because he has the money, the power, the resources. So the reason this bail package looks like this, the reason it's so expensive, the reason he's essentially turning his home into a private prison is because this would be the only way to ensure all of the concerns the government has." They wrote, "The government can't have it both ways. It cannot use Mr. Combs' wealth as both a detention sword and shield." And Sean Combs' lawyers also say that when it comes to a flight risk, the government can't prove it. Mr. Combs clearly intends to face and contest the charges, not flee. Nor do significant penalties and serious reputational harm demonstrate any risk of flight. The government has already destroyed Mr. Combs' reputation, and his only hope is to stand and fight, which he intends to do not only on this front, but also against dozens of civil lawsuits. As for possible penalties, none could compare to the prospect of abandoning his 7 children, his mother, and other family members, as well as the remarkable career he has built for himself. So that was his argument for why bail should be granted and be released pending trial. Now, here is where we believe we currently stand on this bail issue. Sean Combs' team filed a motion asking the Second Circuit Court of Appeals to actually suspend his appeal of the bail decision, meaning don't do anything with it yet. Under the law, we call this holding the appeal in abeyance, meaning don't do anything yet. We want to first have the opportunity to argue the bail issue in front of the new judge overseeing Sean Combs' criminal case, Judge Arun Subramanian, because he had said at a prior hearing, if the defense has any bail application that they would like to raise, then the court will certainly hear it. So that's what it seems the defense plans to do. It seems that they're going to file a renewed motion in front of Judge Subramanian. And it's interesting because in their filing with the Second Circuit asking for them to suspend a decision on the bail appeal, this part is key. They write, "Because certain relevant new information has come to light since the detention order, Mr. Combs intends to file a renewed motion for pretrial release on conditions with an updated proposed bail package in the district court." Now, to be clear, we're not really sure what they mean by new information, but they say that this renewed request is based on changed circumstances. Now, of course, if Sean Combs is granted bail by Judge Subramanian, his attorneys will drop this appeal with the Second Circuit. If Subramanian denies bail, then it seems they're going to take this back up to the Second Circuit. So there you have it, kind of a summary of what's been happening with the bail issue, but we will see where it goes. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.